Ever pondered about the legal mechanics that govern the alteration of states and territories in India? This question is more than a passing thought for those immersed in the world of constitutional law. Our focus today is the Indian Constitution, the supreme law of the land that guides this vast and diverse country. One particular component of this document is Article 4, a legal provision that regulates the alteration of states and territories in India. But it doesn't stop there. Article 4 also enables consequential changes in the first schedule, which lists the names of the states in the Union of India, and the fourth schedule, which details the number of seats allotted in the Rajya Sabha for each state. Therefore, any law that alters existing states or creates a new state does not count as an amendment under this article. Now that we understand the role of Article 4, let's delve deeper into its implications. Article 4, while short, carries significant weight in the constitutional framework of India. It's a tiny titan of a law that has a big job. Let's break this down. Article 4 states that any law referred to in Article 2 or Article 3 will contain provisions for the amendment of the first schedule and the fourth schedule. Now, what does this mean? Well, it means that it allows for consequential changes in the names of the states in the Union of India and the number of seats allotted in the Rajya Sabha for each state. Think about it this way. Imagine India as a puzzle, with each state a separate piece. Article 4 gives Parliament the power to rearrange these pieces to alter their shape, size, and even their names if needed. And the fourth schedule, it's like the rule book that tells you how many pieces each state gets in the Rajya Sabha. Article 4 allows that rulebook to be updated, ensuring that representation in the Rajya Sabha remains fair and proportional. But here's the kicker. Any such law altering existing states or creating a new state will not be treated as an amendment to the Constitution. That's right, it's not considered a constitutional amendment. In essence, Article 4 empowers the Parliament to make necessary changes to the states and territories without having to amend the Constitution. In the brief span of our discussion, we've managed to unravel the complexities of Article 4. This legal provision ingeniously allows for alterations to the states and territories of India, impacting both the IS schedule, which lists the names of the Union states, and the IVERTH schedule, determining the allocation of seats in the Rajya Sabha. Remarkably, any such changes don't call for a constitutional amendment. And so, we see that Article 4, in its brevity, plays a pivotal role in maintaining the dynamic nature of the Indian federal structure.